Hello, dear students. I, Enaniya, Assistant Professor from Government Law College, Ajmer, is present before you to deliver a lecture on the Right to Information Act. So far, we have studied 5 chapters of the Act, and today we shall continue our tour with chapter 6, which commences from section 21 and it is till section 31. Okay, so let's begin. Section 21 provides a protection to all the people who work and who help in providing the information, and it clearly covers the complete chain, because here the word person is used. So first of all, let us listen what is the language of the Bare Act, and after listening to it, I think it will become even more clear to you. Clarity of thought will occur. So that's why. So section 21 protects the action taken by any person. Okay, so it protects action taken by any person under this act in good faith. Okay, so if he does any work in good faith, so any person, if he is doing any work under this act in good faith or intends to do so, okay, either he works so or it is his intention, he is having a intention of good faith, that is, he is having a bona fide faith to provide the information. So it protects the action taken by such person. Okay, so it is giving a protective shield to fortify that person, because he is doing all what he can do in good faith. It is his very good and humble work which he has done. So therefore, law is providing a shield to that person. Clear? Next is section 22. Section 22 is really providing and by reading this particular section, we can come to know the exact power of this act. Okay, section 22 is providing an overriding effect to the Right to Information Act over the Official Secrets Act 1923 and all other laws for the timing in force. So it is making it altogether even more powerful. It is having a far reaching consequence. Okay, so section 22 provides that the Right to Information Act shall have an overriding effect over the Official Secrets Act 1923 and any other law. So the Right to Information Act is having an overriding effect over not only the Official Secrets Act, but also any other law or any other instruments having an effect under any other law for the timing in force. So it is having overriding effect over all these three things. First of all, Official Secrets Act. Secondly, again, any other law is covered, and thirdly, any other instrument created under any other law. Okay, so it covers all these three things, which makes this particular act the most powerful and potent act, because it secures your right to know, so that you as a citizen are more strengthened. Now we shall try to understand section 23. But before understanding it, let us first read section 21 and 23 collectively. Section 21, on the one hand, restricts any individual to take any legal recourse or any suit or any other kind of legal proceedings against any person who has worked under this act. Okay, so at one place it is protecting any action taken in good faith. On the other hand, there is a corollary to this which says bar of jurisdiction. So under section 23, the jurisdiction of any court is restricted here, and it specifically sets out that no court shall entertain any suit, application or any other proceeding for any order made under this act, that is Right to Information Act, and the only legal recourse here is by way of appeal, that too under this act. Okay, so it by providing section 21 and 23 has completely restricted every other individual to take a legal recourse against the rigors of this act, against the orders passed, if any, under this act. So therefore, legal action against that particular individual who has worked under this act cannot be taken. Only and only the remedy which is provided here is by way of appeal. So the individual, if aggrieved by the order of Central Public Information Officer or the State Public Information Officer or their assistants, can only appeal before their superiors or appeal before the State Information Commission or the Central Information Commission, as the case may be. So this is the only legal remedy available to the people who are aggrieved by the orders passed under this act. I think it's very clear to you people. Now we shall try to understand section 24. Section 24 provides that this act shall not be applicable to certain government organizations. So what are those government organizations? First of all, we shall try to understand the first subsection and thereafter the others. So those organizations to which this act is not applicable, those organizations list is contained in the second schedule, which contains the name of 18 organizations. Okay, so these are the organizations which are established by the central government or the intelligence agencies established by the central government. So this act shall not be applicable to these intelligence organizations and agencies which are established by the central government, and no information can be sought which is provided by these organizations to the government. First of all, now there is a proviso to this effect which excludes certain kind of information, meaning is certain informations will be revealed. What are those informations? So if any information is sought for any corruption charges, okay, so if it is a matter of corruption, then you can seek an information, firstly. Secondly, if there is an allegation of human rights violation, then too such information will be provided to you if you are an applicant. Okay, so the proviso excludes two particular grounds. On the ground of these these two grounds, the security organization or the agencies will have to provide the information under the domain of Right to Information Act, which are any allegation of human rights violation and or corruption. Okay, but there is another proviso to this effect, which reads as provided further that first of all, you will have to take the consent of Central Information Commission. Okay. So if any applicant wishes to receive an information which is regarding any corruption charges or which is regarding any human rights violation allegation, so first he will have to take a go ahead from the Central Information Commission, and after a green signal is received by the Central Information Commission, then and only then such information will be provided. And here section 7 doesn't apply, which provides the time limit. Here the time limit is mentioned in the second proviso, that further proviso itself, which is a time span of 45 days. Okay, so within 45 days, these security or the intelligence organizations will have, which are established by the central government, will have to provide the information if the grounds are of corruption or the human rights violations allegation. Is it clear to you people now? So thank you, dear viewers and students, for your great responses. And if there are any doubts or queries, I will definitely answer them. And thank you for listening so carefully. Have a great day ahead. Okay.